All rise, veuillez vous lever. Please be seated, veuillez vous asseoir.
Welcome back. So I hear Mr. Prosecutor, did you want to introduce someone that we've been told? Please, go ahead.
Please, Mr. President, I introduce to my left Colleen Gilg, who's a trial lawyer in the office. Thank you so much.
Thank you very much. Good morning and welcome. Now, we turn to the Office of Public Counsel for Victims. Madam Counsel, the floor is yours for 20 minutes.
Merci, Monsieur le Président.
Thank you, Mr. President. Mr. President, Your Honors, you have authorized 27 victims to participate in today's hearing in your decision of 6 October 2021. Allow me to start by making a preliminary comment relating to the defense's repeated statements and sometimes verbatim relating to the participations of victims in the proceedings before this court, so as to lift any ambiguity as to their role in these proceedings. Mr. Said's defense has continually, from the very beginning of the preliminary phase of the trial, has recalled consistently, and I quote, that the issue of the participation of victims in these trials is a fundamental question that goes to the very fairness of the trial, given that the role of participating victims is one that is broad and varied, and which will impact on the substantive matters and questions that will be discussed during the trial, particularly those relating to the rights of the accused and his innocence. Reference is document 129, paragraph 19. And you can see in document 173, paragraph 7. And also document 88, paragraph 6 and 10. The fact is that Article 63.3 of the Rome Statute allows victims to participate in the proceedings and to express their views and concerns when their interests are at stake, and therefore, necessarily, they speak on fundamental questions, including the confirmation of charges hearing. The fact that victims had, and I quote defense once more, provided narratives in their applications to participate, which point to the responsibility of the accused person and establish a link between the charges brought against the accused person. This does not in any way amount to formulating charges against the suspect. Mr. President, I was referring there to document 109, paragraph 2, 22 and 23, and also document 63, paragraph 48 and 57, as well as paragraph 88, document 88, paragraph 9. The need to demonstrate causality and a nexus between the crimes that charged has no other goal than to enable the chairman to make a prima facie determination on the status of victim. This was also confirmed by the appeals chairman a month ago when it dismissed defense submission that filling out participation forms could, and I quote, influence in one way or another the decisions that will be taken relating to the innocence or culpability of the suspect, and are therefore crucial elements in the preparation of the defense case. The appeals chamber rejected that argument and referenced a decision of 2007 in which the single judge of P Trial Chamber 2 specified that any decision taken in application of Rule 89 of the Rules of Procedure, and I quote, does not have as a purpose to come to a final determination on the nature of the crimes which may have been committed pursuant to the material elements described by the applicant, nor are they meant to determine whether the material elements of each crime have been met. These two aspects go to the determination of guilt of the accused rather than to an assessment of the status of victims whose personal interests are concerned under Article 68(3) of the statute. I am referring there to ICC 0204 101, paragraph 13. Mr. President, Your Honors, the role of victims in this procedure does not consist in formulating any accusations whatsoever against the suspect. That onus is on the prosecution. They therefore intervene in the proceedings because they have a possibility to collaborate to the determination of the truth. They provide and shed light on a different angle, but this is primordial to the quest for judicial truth, which is the very foundation of the procedures for which we are gathered today. Mr. President, Your Honors, the participation of victims in today's hearing, the hearing which is opening today, and also in trials before the court in general, is essential because it is a constant reminder to all that justice rendered within this institution is rendered in the name of the victims in order to preserve future generations from atrocities that defy human imagination and defy our human conscience profoundly, with a view to checking impunity against crimes that affect the entire international community. The crimes that underpin the victimization of victims that we are talking about occur, first of all, in the framework of systematic and widespread attacks, and then in the context of a non-armed international conflict in which two camps clashed to the detriment of the civilian population. Mr. Said is suspected of having committed crimes against humanity, including imprisonment or serious deprivation of physical liberty, torture, persecution, and other inhumane acts. He is also charged or suspected of having committed war crimes, namely torture and cruel treatment, and affecting the dignity of victims, particularly those acts committed at the OCRD between 12 April and also at the Comité Extraordinaire, the CEDAD, from mid-September to 8th of November 2013. Mr. President, Your Honors, the victims who have been admitted to participate do not have much in common among themselves. The vast majority of them are men who were the direct victims of the crimes for which we are gathered today. They come from various ethnic backgrounds and from even broader professional backgrounds. There was really no reason for them to come together or to meet. Yet, they were all arrested arbitrarily, tortured, and they were victims of inhumane treatment. They were detained at the OCRB and CEDAD incommunicado. Some of them finally were released after several days or even several weeks. Some were isolated without any contact with their families, which continually tried to seek and find them. Other victims never came back and disappeared in the jails of the Seleka. Their families henceforth are convinced that they were assassinated in those jails. Their imprisonment is invariably one that occurred in inhumane conditions. They were deprived of water and food. They were often hooded and handcuffed. They were never formally charged. They were detained simply because they lived in certain neighborhoods in Bangui, which were known to be Bozizo's strongholds in 2013. Some of them were detained because they were of Baya or Banda ethnic origin, some because they were Christians, and some because they had worked under the overthrown administration. And because Seleka considered that for these reasons they were people who supported Bozize. The victims and their families are all wondering why they were subjected to such evil. They are therefore expecting explanations from the court. In fact, the victims participating in the procedures today have all testified through their narrative of the events that victimized them. They testify of the particularly cruel nature of the crimes that were committed against them, and also of the systematic and widespread nature of such crimes. Mr. President, Your Honors, these victims and their families also have something else in common. They are terrorized. They live in constant fear of being arrested in the streets in Bangui or to be recognized by their torturers, and some of whom continue to serve within the internal security forces or within the Central African Armed Forces, while others hold high offices within the Central African administration. We must therefore recognize the immense courage that these witnesses have shown in filling out the participation forms which were submitted to you and which I referred to a short while ago. They fear for their security, they fear for the safety of their families, and therefore they all seek to remain anonymous. Regardless of defense arguments, this is their absolute right. It is in no way a whim of the victims. They are not, in so doing, being liars or less courageous people. And talking about courage, as the prosecutor said a short while ago, participating in proceedings before this court exposes victims to potential risks, as I have said. But furthermore, this participation also plunges them back into the hell of the events that they experienced in 2013. Mr. President, Your Honors, I've said this already. Victims are expecting explanations, but they have been waiting for too long, 8 years. They need explanations to be able to forget the tragic events that victimized them. This forgetting enables them to build back, but it is impossible to forget and build back as long as they do not understand why they, their brother, their son, their spouse were arrested, tortured, held in arbitrary detention, sometimes for days and sometimes for weeks, and even some of them ending up being assassinated. For the surviving victims, the persistent pain and the scars on their body following the repeated beatings and things with which they are confronted every day and are constant reminders of the cruelty of the hell they went through and the memories they can hardly forget. They are sad, there is an emptiness in them, there is anger, there is fear of death. They are profoundly traumatized and have been so from the time of these events, and today they cannot sleep and cannot build back and forge ahead. The families of the victims who died are unable to have closure as long as they don't have explanations on what befell their own and the reasons why this happened. Your Honors, Mr. President, building back the lives of my victims calls for a recognition of the crimes that they were subjected to by re-establishing the judicial reasons for which they were victimized and through the punishment of the perpetrators of these crimes, including Mr. Said. Before I conclude, Mr. President, Your Honors, allow me to say a thing about all the other victims. Victims of the acts of violence by Seleka that are included in the PCB, and also such acts that were not taken into consideration by the OTP. The attack of the 7th arrondissement on the 13th April 23, the attacks in Boy Arab on 14 and 16 April 2013, and on 24th August 23, the attack of a minibus in PK9 in Bangui, and the attack of 13 July 2013, thereabouts. I hope that in subsequent matters, they will not be forgotten, because these victims too do exist, even though the applicable law within the court does not give them a possibility to be heard at this time. Most victims lost everything during the events that we are focusing on today, including their professional activities, their ability to support their families and the education of their children, their roles within the family, their health, and their well-being. And in some cases, they simply lost their lives. Victims and families, therefore, are looking to the court because their participation in these proceedings is an essential step in building back their lives. I thank you, Mr. President. I thank you, Your Honors.
Thank you very much, Madam Counsel, for your statements. Now I turn to the defense. Madam Counsel for the defense, you have 20 minutes for your opening statements. Thank you.
Merci, Monsieur le Président.
Thank you, Mr. President. Mr. President, Your Honors, let us briefly revisit the recent history of the Central African Republic. Odile Tobner, a renowned Africanist, stated as follows: the wounds caused by French colonization in Africa manifested in Central African Republic in a particularly visible manner. Nowhere else are those wounds more deep, recurrent, and incurable. At the heart of the continent, this territory in which curses abound bear testimony to the martyrdom of African peoples. The case before us today is an example of the wounds. It is up to us to first of all come back to the context of the charges. It is critical to look into the narrative of the prosecution because their analysis is fragmentary and deficient. Why? The reality does not correspond with the accusation, and so they need to try to transform it. And in so doing, they overlook certain aspects which are crucial. But the facts are stubborn, and we are going to bring them to light. To begin with, the case of the prosecution presupposes the existence of a state, and yet the prosecution never explicitly states that and deliberately maintains a blurred line between the state and the Seleka because it is impossible for them to demonstrate concretely the functioning of the state or the functioning of Seleka. Consequently, one of the crucial elements to understand the prosecution is the concept of the state in the car. Already during the colonial period, overseen by the French, Ubangi Shari was a subject of a practically non-existent administration, to such a point that some referred to it as the Cinderella of the empire. because it was exploited by the colonizers without any benefits for them. Ever since decolonization, Dakar has become a country of instability, which is near constant because of its geographical location. The country is an enclave in a region where insecurity reigns supreme. The lack of control of the security services of the state has as a consequence to leave the country exposed to various forms of banditry. For example, the highway robbers, also known as Zaraguinas. Furthermore, the hinterland of the car is a prime target for attacks from foreign groups, for example, the continuous attacks of the LRA. In this complicated security context, the Central African state seems to have lost, ever since the 80s, its institutional capacities, preventing it from being functional and ensuring the security of its territory. It is for this reason that several experts define the Central African Republic as a shadow state. And this is a second element which is crucial to be taken into consideration if we want to understand the evidence of the prosecution. In response to that model of a shadow state incapable of protecting its populations, in particular in the hinterland, non-organized and opportunistic armed groups proliferated. And these are groups which progress constantly, quarreling amongst themselves. Others sporadically rallied with the FACA, and others were fighting against each other, while others still set themselves up as opposition to the powers that be. Another key of understanding is the conditions under which the presidency of Francois Bozize took place over 10 years. Ever since his arrival in power, it was an anti-democratic regime characterized by serious violations on human rights, and the prosecutor seems to have forgotten that. This is why, as early as the 2000s, non-centralized groups took advantage of these groups and transformed those entities into civilo-politically armed groups with the intention of participating in peace agreements or ceasefire agreements. During these hearings, we will go into the details of the creation and composition of each of those groups in order to demonstrate how the alliances and splits amongst those groups prevented them from forming an entity that is homogeneous and structured. And these were the groups which formed on a temporary basis in 2012 the coalition known as Seleka. And this is crucial because the prosecution in its DCC and PCB relies on a vague concept that does not cover any concrete reality, and that is Seleka. The word Seleka simply means alliance or coalition in the Sango language. It is therefore imperative to look into the reality encompassed by this word. From the prosecution evidence, it emerges that Seleka is a nebulous entity made up of various groups who, for a brief moment in time, coalesced against a common enemy, President Bozize, and which disintegrated once the common threat disappeared. And a striking example of the prosecution's penchant for denial of the disorganization of these groups is the arrival of those groups in Bangui in March 2013. According to the prosecution, it was Michel Jotodia who issued the order to take over Bangui. And yet, from the evidence, it emerges that Michel Dotoja had been taken hostage in Bambari, that he had been detained incommunicado by other members of the Seleka, and that he only learned over the radio that the groups were moving towards Bangui. It is all the more fundamental to look into what the expression Seleka stands for if we consider that once President Bozize left power, it is that Seleka that became the state according to the prosecution. We have said that the coalition disintegrated once the government of national unity was put into place in accordance with the Libreville Agreement. Roland Machel, a research fellow in the CRNS, explains, in the months that followed, the Seleka was merely a cowardly confederation of armed groups living off the population. Their chiefs were unable to control them, and the chain of command was almost inexistent. It is therefore not possible to use the word Seleka to refer to the state. The most flagrant example of the confusion deliberately created by the prosecution between the Seleka and the state is the fact that they described the OCRB and SEDAD as a Seleka bases, and yet the ORCP was created by French cooperation in the 80s, and it was part of the state structure ever since that date. Furthermore, as from the creation of the ORCB, it was Commissaire Mazenge who was responsible, and he was the same commander in charge at the relevant period of the charges. The OCRB was placed under the authority of the Director General of the Police and the Ministry of Security, and therefore it was part of the state structure. And the prosecution evidence reveals that arrests and detentions at the OCRB were done under the jurisdictional control of the public prosecutor. It is worth pointing out that many detainees at the OCRB were people that were described as Seleka members. So, what is the prosecution telling us? That OCRB is supposed to be a Seleka base with detainees which are Seleka in their majority. By using the word base, the prosecutor alludes to secrecy, but the ORCB was an open space frequently visited by the Red Cross, NGOs, and representatives of French authorities. For example, a French soldier stated that most of the time the people detained were free within the compound. Only the most dangerous people were detained. I rarely saw anyone locked in the cells that were there. I will say a word on the functioning of the OCRB. We must be realistic. With very limited staff and in a situation of total chaos and faced with a limited state structure, Mazenge used elements who had volunteered, including Mr. Said. That does not mean that there was a structured functioning within the OCRB. Several witnesses, in fact, state that it was not possible to say who was in charge of the ORCB. A knowledgeable witness told us, "You are asking me who was at the head of the OCRB? It is difficult to say because it was changing all the time." In order to try and circumvent the structural problem inherent to the OCRB, the prosecution preferred to make assumptions regarding the role of Mr. Said. We will demonstrate that such a process prevents the prosecution from establishing any responsibility of Mr. Said because they postulated without any proof that Mr. Said was allegedly in charge, and therefore they considered that he was de facto responsible for everything that happened in the ORCRB, whether he was physically present there or not. In fact, we have heard that Mr. Said was responsible for events in Boyrab, and that is new. It is not in the DCC, it is not in the PCB, and if these are new charges, we do not know about them. The reality is that ORCB was in total disorganization, and so in such a situation, there are no responsible people. Mr. Mazenge, trying to assist Mazenge, cannot be held responsible for the acts of other people who claimed to be occupying various positions. In such a context of disorder, it would be impossible for the prosecution to prove any state or organizational policy or any common plan. Still, in order to try and cover up the factual complexity of the situation on the field, the prosecution states that there was a non-international armed conflict in the car between the end of 2012 up until the 10th of January 2014. By targeting a particularly broad period without specifically focusing on the relevant period of the charges, the prosecution is trying to give an impression of continuity in the political military situation in the car. Nothing could be further from the truth, and nothing could be any more simplistic. We shall demonstrate in our oral submissions that nothing makes it possible to establish the existence of an armed conflict between March and September 2013. And this is a conclusion confirmed by the case law of the court and by the literature of available experts. And we will come back to that. And wherever there is no armed conflict, there is no war crime during the period targeted by the charges. And so, why does the prosecution present such a truncated account? Because the prosecution did not want to look into the people that were really responsible in order to understand the events. The prosecution used every weapon in their arsenal to show that there was the existence of a non-international armed conflict. But then, who are those people who represented that so-called functional state? Where are the highest ranking leaders of that Seleka? Why is that? Is it that the prosecution is not interested in them? Is it because those leaders are not known? To the contrary, they are known to everyone. Or is it because they are in hiding and they cannot be found? Quite the contrary, they are not in hiding. Their testimonies would be fundamental to establish the truth, and based on what they will tell us, it will be necessary either to prosecute them or to drop the charges against those who were part of the structure set up by the transitional government of President Jotodia. That is the logical thing to do. Either the accusation considers the testimonies of these high-profile actors of the crisis as credible, and in that case, any person prosecuted as part of the state structure existing under President Jotodia would then have to be freed thanks to those testimonies. Or the prosecution considers that these people played a questionable role in the crisis, and as high-ranking leaders, they would be prosecuted by the court. Questioning the highest-ranking leaders will make it possible to present a false account of the recent history of the car, and it will avoid validating this account. So why are these high-ranking officials not of interest to the prosecution? The response, Mr. President, Your Honors, we will try to give it in private session. And before we go into private session, I would like to point out that this will be the last subject of my presentation. Mr. President, please, if we can go into private session.
Madam Counsel, you are left with 1 minute. Do you know it? Okay, Mr. Court Officer, let's move into private session, please.
We're back in open session, Mr. President.
Well, we are now back in open session. The defense for Mr. Said has concluded her opening statements. Now the parties will have the possibility, under Rule 122, Paragraph 3 of the Rules of Procedure and Evidence, to raise objections or make observations concerning an issue related to the proper conduct of the proceedings prior to the confirmation hearing. I will remind once again that the issues and objections which were already brought to Chamber's attentions cannot be raised and should not be raised at this stage. And I also recall that pursuant to Rule under 22, Paragraph 4, at no subsequent point may such objections and observations be raised or made again in the confirmation or trial proceedings. Please adhere strictly to the time allocated. And now we start with the counsel for the defense. Madam Counsel, the floor is yours.
Merci, Monsieur le Président.
Thank you, Mr. President. Dove Jacobs will present our observations on this matter. Thank you, Your Honor.
Matt Jebus, the floor is yours. Mr. Jacobs, let me add that the prosecution has indicated that they do not intend to raise objections or make observations, so we will give you at the latest until 1 when we will adjourn hearing. Okay?
C'est bien compris, Monsieur le Président.
I have understood, Mr. President. Mr. President, Your Honors, when you allowed defense to raise any questions on the regularity of procedures prior to the hearing, Rule 123 has a corrective or remedial function in that it deals with anything that pertains to the fairness of the procedure, giving opportunity for such discussions to take place upstream before this trial and before any discussions on the merits. Specifically, the beginning of the hearing is the single opportunity for a party to make an assessment of the entire procedure that occurred before the hearing and to raise on that basis a number of exceptions and make a number of observations. This crucial moment in the hearings allows the parties and the chambers to read the procedure of any defects that might undermine the proper conduct of proceedings in general, and by extension, the decision on the confirmation of charges that will follow. Defense notes that relating to the functioning of Rule 122, the last version of the practice guide for chambers, which was published in 2019, brings together the ideas of the judges of the court relating to what should be best practices when it comes to conduct of proceedings, and in that regard states as follows at paragraph 46. Challenges as to the form raised under 123 may also deal with timelines to allow to the parties to prepare for confirmation of charges. It is therefore pursuant to the letter and spirit of Rule 123 that we make the following observations on behalf of defense. First of all, relating to the DCC and the PCB pre-confirmation brief. The document containing the charges is an essential document. It is the first document that enables the right of the person who is being accused to be notified of the charges. It is also the basic document on which defense works. In this case, let us point out that it is the PCB, the pre-confirmation brief, that is the DCC, which is referenced at as a footnote in the prosecutor's document, which indeed has become the basic working document of the defense. In fact, the DCC, without references, is only a series of allegations that are not buttressed or demonstrated. This document only derives meaning when the PCB then provides the chamber and the defense with the manner in which it intends to support its incriminating charges. The DCC has a final function of focusing discussions, because it is on the basis of the DCC that the chamber will decide either to dismiss the charges or to confirm only those for which it would have decided that the prosecution provided substantial grounds to believe that they have been so established. Now, for the DCC and the PCB to play these key roles in the proceedings, we also need to fulfill these documents also need to fulfill a minimum requirement of clarity. But this is not the case for the defense. And we shall demonstrate this by using a few examples. First, defense was able to observe that quite frequently the prosecution simply expressed an affirmation within the body of a text and then would refer to a footnote to one or several references without mentioning the content of the evidence or the witness statement to which they are referring to, that is, to which prosecution is referring to. In terms of methodology, such an approach does not amount to a genuine demonstration. When there is no clear explanation as to why evidence underpins an allegation, when there is no hierarchy established between the various pieces of evidence, when no indication is provided as to the authenticity of the evidentiary materials or the credibility of the witnesses, the prosecution deprives defense and the chamber of essential tools with which to assess its case. Defense and the chamber therefore find themselves in a position where they themselves must reconstitute the arguments and submissions that prosecution would have done rather clearly in its PCB. Clearly, we observe that the prosecutor used what could be referred to as an IKEA method in its demonstration, where the reader is provided with an allegation, an ERN code, and then has to reconstitute the demonstration by himself or herself. Secondly, the manner in which the charges are pleaded cumulatively does not allow the defense or chamber to fully understand what the prosecutor encompasses in each of these charges. Cumulative charging does not excuse the prosecution of the requirement to provide a coherent narrative of its charges. In fact, when legal qualification is retained as such, this is not a technical detachment of qualification, because qualification in itself should be a narrative of the story.
Une qualification juridique raconte un point de vue, une histoire.
Legal qualification narrates a point of view, a story which enables understanding, particularly in relation to the alleged perpetrators.
À l'intention des auteurs allégués. Pardon, je vais répéter la dernière phrase juste pour qu'elle soit claire.
Let me repeat the last sentence to be clear. Legal qualification narrates a point of view, a story, on the manner in which an incident is understood, particularly in relation to the intent of the alleged perpetrators. Therefore, when it comes to a narrative, a specific incident cannot be at the same time a war crime and a crime against humanity, because each obeys a specific logic in its narrative. But the prosecutor never explains incident by incident why such and such an incident is characterized in one way rather than in another, and even less so how the incident as described dovetails with the narrative on a war crime or crime against humanity.
On constate ici que
Therefore,
l'accusation dans sa démarche
we see that
va
the
même plus loin dans la
prosecutor
méthode IKEA.
uses the IKEA method even
Que sur
further
ces questions, il y a non
because
seulement des éléments
on
disparates,
several issues, the
mais encore nous ne savons même
evidence
pas
is
quel
not
meuble
only
nous sommes censés reconstituer.
diverse because we do not even know the type of building that we're supposed to piece together.
Troisièmement, un
Se-
mot sur la
third.
qualification juridique des faits.
When it comes to
L'article
legal
7.1K
characterization of facts under 7.1K,
Le procureur retient pour les chefs
other
d'accusation 5
Inhuman Acts, the prosecutor relies on charges 5 and 12.
Déjà, il convient de rappeler que cet article du statut
Let us point out that this article in the statute is not without controversy and without difficulty
puisqu'il invite en réalité les
because
juges
it actually
à étendre
calls
par analogie,
on the judges
puisqu'il
to
évoque des actes de caractère
determine by
analogue,
analogy because it
le champ
speaks
d'application
of
matérielle du
similar
statut,
acts in the determination of the
en
material
contradiction
scope
directe
of the
avec
Rome
le principe
Statute,
de légalité.
which is in direct contradiction with the principle of legality,
Qui prévoit à l'article 22 du statut
which under Article 22 of the statute provides that
et
the
d'interprétation
definition
stricte
of a crime should be interpreted strictly and cannot be expanded by analogy.
Dans ces conditions,
In these conditions, therefore,
l'article 7.1K
Article 7.1K, if used, can only be used in exceptional circumstances and cannot be a portmanteau for the prosecution in which he includes everything that doesn't fall in the other categories, as if one were sweeping things under the rug. This actually is what the prosecution does, because in its legal characterization, it succinctly outlines a number of legal criteria and then goes on to outline a series of factual, disjointed allegations without making any effort to determine how these allegations meet the legal requirements as they ought to. In these circumstances, therefore, the charges 5 and 12 should be discarded in limine for lack of precision.
J'en viens à ma seconde série d'observations relative à l'analyse des divulgations du procureur.
Now, my second series of observations is about prosecution disclosures and what it tells us about the deficiencies in its investigations and therefore challenges the whole foundation of the trial. First of all, we must recall the scope of the divulgation undertaken by the prosecutor in relation to the confirmation of charges hearing. More than 12,000 elements, pieces of evidence were disclosed. 60,000 pages of documents were disclosed. To fully grasp the scope of the disclosure, let us say that the 60,000 pages are 20% higher than the evidence disclosed by the prosecutor before the beginning of trial in the Bagbo and Blegude case. First of all, this is a significant volume of evidence that is not obvious when we look specifically at what is referred to by the prosecutor as incriminating evidence and try to relate them to the various charges or
L'accusation l'a
allegations.
retenu pour directement soutenir les allégations.
The prosecutor, in support
Dans le
of
PCB,
his
qu'environ 800
allegations,
éléments de preuve
used
sur
only
les
800
69
pieces of evidence,
éléments in-crime divulgués.
that is 8,000 incriminating evidence as disclosed.
Ce qui laisse la défense dans la situation de devoir deviner
This leaves
à quoi
defense in
servent
a
aujourd'hui
position
les 7
where
925
it
éléments
must now
in-crime
second guess as to how the 7,000 other pieces of evidence will be used in relation to the remaining
Deuxièmement,
crimes.
avec un tel volume
Secondly,
d'éléments de preuve divulgués,
with such a volume
on pourrait au moins
of
s'attendre
disclosures,
à ce que le dossier
one
contienne
could
tous les
expect
éléments
that
utiles.
the files would include all useful and relevant
Tant en ce qui concerne la
elements,
preuve à charge que la preuve à décharge.
inculpatory as well as exculpatory evidence.
Or, que constate-t-on à l'analyse de la preuve divulguée?
Yet, when we analyze the disclosed materials,
Que le procureur a très peu
we
d'éléments
note that the prosecutor has
d'acteurs importants de la crise.
very little material from major stakeholders
Par
in the
exemple,
Central African
364 éléments.
crisis. For
Je rappelle,
example,
sur les 12 000,
364
364 éléments
pieces
de
of
l'Union
evidence
africaine.
out of the 12,000
Seulement un peu plus de 200 pour la preuve à décharge.
relate to about. Sorry, Mr. President, we didn't follow what
Zéro
Counsel
élément de
said at that
doute.
point.
Mr. Counsel,
Oui.
would you please repeat? Because we have lost something. Thank you.
Bien sûr, je répète. Donc,
Let me repeat, 364 pieces of evidence from Central African authorities from the 12,000 pieces of evidence disclosed by the prosecutor,
dont à peine 200 portant
amounting to,
sur la période des
out of which only about 200 relate to the period for which charges are brought.
Nous avons zéro élément
We have
des autorités
zero
sud-africaines.
material from the South African authorities, whereas we know that it was the main international contingent on the ground, particularly in early 2013.
Zéro élément des
We have
autorités tchadiennes.
zero elements
Alors même que
from
l'implication
Chadian
du Tchad dans les
authorities,
crises
whereas
successives en République
Chad,
centrafricaine est connue de
even
tous.
in successive writings on Chad, they are on the Central African Republic was fully involved, as is known by all,
Pour évoquer deux autres
involved in
sources
those
importantes,
crises in
non
the Central
exploitées par
African Republic.
l'accusation,
There are other sources that have been unused by the
en audience à huis clos partiel.
prosecutor, and for that reason, I would like to talk about them in private session, Mr. President, with your leave.
Mr. Court Officer, we will move into private session.
We're back in open session, Mr. President.
Thank you very much. Mr. Counsel, please.
Dans ces conditions,
Under these circumstances, it should be noted that the case file of the prosecutor is incomplete and fragmentary because it is lacking most of the useful elements from actors who were in fact important in the crisis. Conducting proceedings on such a defective case file is taking a risk of missing the essential parts and drawing conclusions on the basis of incomplete information.
il ressort de la preuve de
Thirdly,
l'accusation
it emerges from the prosecution evidence that they did not investigate in a neutral manner to establish responsibilities and prosecute those they felt to be the ones most responsible for the alleged crimes.
alors que le
While the
procureur invoque de manière
prosecutor
répétée
repeatedly invokes
dans son
in
DCC
his DCC
une responsabilité au plus haut niveau
the responsibility at the highest level of what they refer to as Seleka,
il n'apparaît qu'il n'ait pris aucune
it
mesure pour
appears
poursuivre ces hauts
that
responsables.
he did not take any measures to prosecute those high-ranking officers.
Monsieur le Président,
Mr. President,
je dois passer de nouveau, si
I would
avec
like
votre
to go
permission, de
back
nouveau à une
once
vidéo partielle, et
again,
ce sera la
with
dernière
your
fois.
permission, briefly
pour ma
into
présentation.
private session, and this would be the last time for a certain issue.
Mr. Court Officer, we'll move into private session, please.
We're back in open session, Mr. President.
Thank you very much, Mr. Counsel. Please proceed.
Merci, Monsieur le Président.
Thank you, Mr. President.
Face à ces éléments,
Faced
l'on peut
with
se
these
demander
elements,
si
one
l'enquête de l'accusation,
can wonder
plutôt que d'avoir été menée de manière sincère,
why the investigation
Dans la
of the
recherche de la
prosecutor,
vérité,
rather than being conducted
conformément aux
sincerely
obligations incombant au bureau du procureur
with
en
the-
vertu de l'article
in the
53
search
du
for
statut,
the truth in accordance with the obligations of the prosecutor pursuant to Article 54 of the Rome Statute was not from the very outset
avec certains acteurs de la crise,
based on compromises with the various actors of the crisis, in contradiction with all the principles of a fair and impartial justice.
ce constat vicié à l'évidence,
This
toute
issue
l'enquête ayant mené à ce que nous soyons là
constitutes
aujourd'hui,
a defect in the investigation which
et
has
remet en
brought
cause
us here
la procédure
today
dans son ensemble.
and undermines the proceedings in their entirety.
J'en viens à mon troisième et dernier point.
Now I will go on
Nos
to
observations
my
générales
third and
sur
last
l'équité de la
point,
procédure qui a
general
précédé la
observations on the fairness of the proceedings that preceded these hearings.
Et juste avant de continuer, Monsieur le
And
Président,
before I
j'ai
continue,
bien compris
Mr.
que je
President,
pouvais,
I
disposer du temps jusqu'à 13 heures.
have
Je vais essayer de finir
understood
avant, mais juste
that
pour
I
être
can go on to 1 p.m. I will try to finish before that.
La défense,
The
au
defense,
cours de la phase qui a précédé l'audience,
during the
confirmation des
phase
charges,
which preceded the
a soulevé au fur et à
confirmation of charges
comme c'était son
hearing,
droit, son
raised as time went on,
un certain nombre de questions
as is their
qui affectaient la
duty, a
capacité
certain
de la
number
défense
of issues
à
that
exercer ses
affected the ability of the defense to exercise
conséquent,
its rights, and as
qui
a
portaient atteinte à l'équité de la
consequences
procédure.
which undermined the fairness of the proceedings.
Pour estimer que la défense
To
n'avait
deem
pas
that the
besoin de mentionner ces
defense
questions
did not need to
en
mention
détail
these
aujourd'hui, ce que nous ne
issues
ferons pas,
in detail
La Chambre a
today,
estimé
and we are not going to do that. The chamber felt,
et je cite l'écriture 188,
and I
15,
will quote document number
il
188,
n'est pas clair une
paragraph
fois l'instruction de la
15.
Chambre
It is unclear how the chamber's instruction
de ne pas répéter
not to
telles
repeat such
observations ou objections
observations or objections
que la Chambre a déjà
which the
tranchées
chamber has already disposed
et ont par
of
conséquent peu
and
de
which
chances
are
d'être
therefore
considérées à nouveau,
unlikely to be considered again
pourrait affecter les droits
would
de la
affect the defense's rights.
défense. Fin de citation.
End of quote.
La Chambre
The
estime
chamber
donc
is of
parce
the
que les
opinion that
que la défense aurait
because
voulu
the
soulever aujourd'hui
issues that the defense wanted to raise
ont déjà été
today
tranchées par
have
les juges,
already been disposed of
il
by
ne
the
serait pas
judges,
nécessaire d'y
it
revenir,
would not be necessary to revisit them
puisqu'elle ne serait plus discutée à
because
l'avenir.
they will no longer be discussed in the future.
Néanmoins, la défense
Nevertheless, the
respectueusement
defense respectfully
cas.
submits that that is not the case.
Pourquoi?
And why is that?
Parce que ces
Because
questions,
these issues,
si elles ont certes été tranchées par la
even
Chambre,
though they were indeed disposed of
n'ont pour la
by
plupart pas
the
fait l'objet
chamber,
d'une évaluation
for the
par la plus
most
haute
part, were
chambre de
not
cette
the
Cour, la
subject
Chambre
of
d'appel.
an assessment by the highest
donc n'ont pas été
instance
tranchées
of the court, that is the appeals chamber, and therefore there was no final decision taken.
Un exemple
One
de question qui n'aura
example
pas pu être porté
of
devant la Chambre d'appel.
issues that could have been taken to the appeals chamber.
Alors que la défense avait détaillé, sujet par sujet,
Even though the defense
le nombre
had
d'heures dont elle estimait
detailed
avoir besoin pour
subject by
présenter sa défense
subject
pendant
the
cette
number
audience,
of hours that they needed
contester
to
les charges,
present its observations during
la Chambre
the
s'était fondée
confirmation
sur son
of
pouvoir discrétionnaire
charges
et la
hearings
célérité de
in
la
order to
procédure
challenge
pour donner un
the
chiffre, celui de 3h30,
charges.
beaucoup plus court.
The chamber relied in a generic manner
motiver.
on the invocation of its discretionary powers and expeditiousness of the
Néanmoins, le fait que les
proceedings
juges aient une
to
marge de
give
discrétion
a number.
dans l'exercice de leurs fonctions,
However,
ne veut
the
pas dire qu'il ne faut
fact
pas
that
motiver
the
les
judges have a margin of discretion in the exercise of their functions does not exempt
Ici, la
them
défense
from
demandait
their
un peu plus de 3
obligation
jours
to
d'audience
justify their
pour
decision.
présenter sa défense.
Here, the
Dans
defense
une audience de confirmation des
requested
3 jours,
3 days of hearings to
pas une
present
semaine, pas 3 semaines.
its
3 jours.
challenges,
comme
not 3 days, not 1 week, not 3 weeks, 2 or rather 3 days, which were
Juste un
considered as being
Cette
too
position
much.
était d'autant plus étonnante
This position was
que,
all the
rappelons-le,
more
l'audience de confirmation
surprising
des charges avait été repoussée le
because
30
if
juin
we
2020,
remember well,
le 30
the
juin dernier,
confirmation of charges
du 5 au 12
hearing
octobre 2021
was
par la Chambre.
postponed on the 30th of
Pour quelle
June
raison?
from the 5th to the 12th of October
Et je renvoie à la décision
2021. And for what
112,
reason?
paragraphe
And
15.
I refer you to decision 112,
Des
paragraph
développements qui se sont
15.
produits dans l'emploi du temps de la sécurité
Developments
judiciaire,
having since occurred in the schedule of the
le calendrier de la
judiciary,
Cour et les
the court's
responsabilités
calendar,
concurrentes
and the
des juges de
concurrent
la Chambre
responsibilities of the judges of the
rend
chamber
nécessaire de
in
reprogrammer
other
cette date,
proceedings make it necessary to reschedule
tout en
this
préservant
date
la célérité de la
whilst
procédure.
preserving the expeditiousness of the proceedings.
L'audience a donc été reportée d'une semaine, 7 jours, du 5 au 12 octobre,
So the hearing was
Pour des raisons
postponed
purement
for
logistiques, qui n'avaient aucun
1
rapport avec
week,
l'affaire.
7 days from the 5th to the 12th of October 2021
qui
for
avait rapport
reasons
avec l'agenda
that
des
were
juges
purely
ou le calendrier de la
logistical
Cour.
and with no
Mais quand la défense
relationship
elle-même
to the
a
case.
demandé 2 ou 3 jours
The
pour présenter
defense
sa
asked
défense,
2 or 3
la
days
célérité de la
to
procédure
present
était invoquée
its defense, but the expeditiousness of the
cette question
proceedings
pourtant
was
cruciale
invoked.
n'aura pas pu être portée devant la
So
Chambre
this
d'appel.
issue, which was crucial, could not therefore be lodged
exemple, et je n'y reviens
before
pas, c'est
the
celui dont on a parlé
appeals
ce matin,
chamber.
c'est la
Another
question du temps
example,
dont
and
la
I
défense a
will
pu
not come
disposer
back
pour analyser la preuve du
because
procureur.
we talked about it, is the time that the defense
Elle-même
would
ne
have
sera pas
had
portée devant la Chambre d'appel.
to discuss the prosecution's charges. That was not. It was not possible
dernier
to
point sur
take
cette question
that
avant de
to the appeals
Il
chamber.
était d'autant plus important
One last
que
point
la défense
before
puisse pouvoir analyser la
concluding.
totalité de la
It
preuve
is important for the
que les
defense
juges
to be
de la
able to
Chambre criminelle
analyze
ont accès.
all the prosecution
qu'elle
evidence
fait partie du
and
dossier
that
de
the
l'affaire.
pre-trial chamber should have
Et que si
access
l'on en
to
croit
them.
la jurisprudence
It
récente de la Cour,
makes part,
la Chambre
it is
criminelle
part
peut s'en
of the
servir
case, and
lors de la rédaction de la décision de
based
confirmation
on
des charges.
the case law, the pre-trial chamber can use that information for the confirmation of
Ainsi, dans
charges
la décision de
hearings.
confirmation des charges
And
dans
so
l'affaire
the
Abdel-Rahman,
decision
9
of the
juillet 2021,
confirmation of the charges in the Al-Rahman
la
case
Chambre
of
précisait
this
qu'elle avait,
19th
je cite,
July
analysé la totalité de la
2028,
preuve
the chamber
matérielle
said
publiée par
that
l'accusation.
they were able to analyze all
En
the
plus des éléments mis par le
evidence
procureur sur son inventaire de preuves.
disclosed by the prosecutor, in addition to the evidence
Il ressort de ce que
included
nous venons
by
de dire
the prosecutor.
qu'interdire à la défense de se
So-
préparer dans de bonnes conditions
preventing the
créer le risque
defense
que la
from
décision de
preparing
confirmation des charges
itself
soit rendue sur la base d'éléments
in
de preuve
good conditions
Chambre
is
aura
creating the risk
que la
that
défense
this
n'aura pu pleinement
will
contester.
be done under circumstances that
qui
cannot be
remettrait en cause
analyzed by the
l'équité de la
chamber,
procédure dans son
and that will call into question the fairness of the proceedings in their entirety.
J'en finis, Monsieur le Président.
And
Madame,
I
Monsieur
will
le juge,
conclude,
le constat
Mr.
qui ressort de nos
President,
observations.
Your honors,
L'audience de
on
confirmation
what
des charges
emerges.
débute
The
aujourd'hui sur le fondement d'une
confirmation
triple violation des
of
droits de la défense.
charges hearing begins today on a triple violation of the principles of the confirmation
Un
of
DCC et un
charges.
PCB
A DCC and a PCB.
Pardon, je vais répéter la dernière phrase.
And I will
Donc, je
repeat
disais que
the last
l'audience
sentence.
commence
I'm
sur
saying
une triple violation
that
des droits de la
the
défense.
hearing is beginning under a triple violation of the rights of the defense.
Premièrement, un DCC
First of all, a
et un
DCC
PCB
and a PCB
qui ne satisfont pas aux
that
exigences
do not meet the
en matière de
requirements
clarté et de
in
notification
the
des charges.
area of clarity and notification of charges.
Une enquête qui
An
n'aura pas été menée de manière
investigation
sincère,
that
qui vicie
was
la
not
procédure.
carried out in a sincere manner and which
Une
undermines
violation
the
des droits fondamentaux
proceedings,
de la
a
défense
violation of the fundamental
en
rights of
matière
the
de respect de
defense
son temps
in the
à
area
disposer,
of
de son droit, pardon,
the
à
respect
disposer du temps nécessaire à la préparation de
their
l'audience.
right to have the necessary
Violation
time
qui
for
n'aura
the
pu être reportée devant la
preparation
chambre d'appel.
of the hearing, a violation that could have been brought before the appeals chamber.
Violation qui n'aura pas pu être
A
portée devant la chambre
violation
d'appel.
that was not able to be brought before the appeals chamber.
Ces violations,
That
si
violation,
elles n'étaient pas corrigées,
if
réduiraient la phase de confirmation
not
des charges
remedied,
à un exercice
would
de validation
reduce
superficielle.
the confirmation of charges
Rubber
phase
stamping
as
des
a
allégations du
validation or rubber stamping of the allegations of the
ce qui irait à
prosecutor.
l'encontre de la lettre et de l'esprit
So
du statut
this
de Rome.
goes against the letter
Dont
and
les juges sont
spirit
pourtant les garants
of the Rome Statute, and
et serait contraire à l'ambition
the judges
d'exemplarité
are the guarantors,
laquelle
and
s'attache la
it
Cour
will
pénale
be
internationale.
contrary to
Je vous
the
remercie.
exemplary nature of this court to which the international community is attached.
Thank you, Mr. Counsel. All your observations have been duly noted. Mr. Prosecutor, will you respond? Do you intend to respond to these observations?
Your Honor? Your Honor?
Yes, please.
Is it working? Yeah, sorry. We would like to respond briefly to what has been provided by the defense. However, if possible, if we could have 5 to 10 minutes to discuss some of the issues that were just raised very spontaneously now, that would be most kind.
Yeah, well, in any case, I was asking just to evaluate about the conduct of the proceedings. What I will do, I will adjourn the hearing for the lunch break now.
All right.
And we'll
And then we
reconvene it in 1.5 hours. And at the very beginning, you'll be allowed to make your observations. So, okay, so now it's 12:55 almost. So,
Mr. President, perhaps with your leave, as we've got
Mr.
5
Prosecutor.
minutes, I won't be
you
here
wanna start
after
now?
the break, so perhaps with your leave, I can just give some spontaneous responses
if you want to start
for
now,
5 minutes, and then
if you want to start now, you're allowed
indeed.
to do so.
I'm grateful. Your Honours, it seems at the outset that my learned friends have not completely, they've sought to revisit matters that have been already adjudicated. My initial response is that in terms of the disclosure, the comparators are quite inappropriate. Both they are complaining that there's too much evidence, and yet also at the same time that they've been given too little. The key issues regarding the amounts of items referenced in the document containing charges and in the pre-confirmation brief should, if anything, give some assurance to the defence that particular documents have been relied on, that gives a clear target for them to challenge in this hearing. But the other arguments regarding the unavailability of evidence from various state parties or actors that may, they say, have been in the region is entirely speculative, and one that one struggles to see what is the prejudice from the defence. Of course, they have their rights also to obtain evidence and information from any sources. It's not just the Office of the Prosecutor, but these arguments that they raise that this country or that country or this organisation must have had evidence is really an argument of conjecture that really can be given, we say, very short shrift. In terms of the very nice, and I commend my learned friend for it, the very vivid IKEA model, I think IKEA has been given a bit of a bad rap. Sometimes the instructions are extremely clear, and of course people walk to the shops for a reason. But leaving that particular argument to one side, in terms of the substantive arguments, any written pleadings or any arguments when the defence put forward their case, they can challenge if there's inaccuracies in the footnotes, or if footnotes don't support propositions, or if the evidence disclosed does not meet the confirmation standard. Well, this hearing is exactly the opportunity for them to point your judges in the right direction, and the office, and so that only a case that is supported by evidence can go forward. Your Honour, I won't say anything more regarding the allegations that the Office of the Prosecutor doesn't investigate neutrally. I don't think much attention needs to be given to that. It's a statutory requirement, and if there's any substance to that, action can be taken. But again, the argument about which witnesses are called, and particularly at this stage of the proceedings, is one that is not a really intrinsic or relevant consideration at this stage of proceedings. Your Honour, I think my learned friend Leonie Van Braun will probably have some more pertinent and significant arguments to make after the break, but they're my immediate reaction. Certainly there's nothing to say that the individually or cumulatively the various complaints, if I can put them like that, I say they're no more than really than complaints, that have been put forward by the defence are such that give any basis for their contention that there's a defect in the proceedings up to this point. It's a try. Your Honours will decide if it's a good try or not, but we say it can be dismissed quite summarily. Thank you.
Thank you, Mr. Prosecutor. Then we're almost at 1. I will then adjourn the hearing for 1.5 hours for lunch break. We will therefore resume at 14:30 with the Office of the Prosecutor continuing with their observations. Thank you very much.
All rise, veuillez vous lever.